Hello students, so today's topic is drafting of reports and projects. So these legal reports that are drafted are typically referred to as legal memorandum or memos, and they are designed to outline and explain the legal and the factual issues in a case. Usually, these legal memos are written by a younger associate attorneys to lead the attorney on the case, or they are written by a law student to their professors for law school classes. Legal memorandums can be written in purely objective style to explain the legal issues and the outcomes of the neutral format. They can also be framed as a persuasion designed to present the best possible case from a specific party perspective. Legal reports are also known as legal memos, as told, and they are the legal documents that inform the attorney or the judge about the legal issues in any case. There are two types of legal reports that can be written. The first category is known as the objective report. In this, it explains all the legal issues from a neutral point of view, and the second category can be a persuasive or a moral, which with all the facts and the legal arguments from another point of view. So legal research reports provide the description and resources on different issues and events. Formatting the memorandum, this legal memos. So you should use a traditional font in formatting such memos, and you should use the Arial or Times New Roman in 12 point size, and the margins should be adjusted in a uniform 1 inch of all sides, unless there are some instructions that are given to state wise. Some offices prefer a larger margin on left side of the page. Set justification to left so that spacing is not distorted. Some find it helpful to start by filing out the expected section captions as a sort of bare bones outline before beginning the work of writing the draft. So the firm or the law school may use different names for these sections, but essentially the needs for this legal memo are heading or the case caption, questions that are presented or the issues, brief answers to these issues or the questions, a brief recitation of the conclusion, statement of facts, discussions or analysis, and conclusion. Keeping in mind of the audience for the memorandum or the report, typically these type of reports are written for the attorney or the law school professors who have extensive knowledge of the law in the relevant area, but it may not be familiar with the facts of the specific case. The outline and the customary sections are designed to help the reader focus on the most important information without being distracted by extraneous details. So, as for line spacing, often the questions presented and brief answer sections are single spaced, and while the remainder of the memo is double spaced. So, questions presented. The first section in your memo provides a detailed fact supported statement outlining the specific questions or issues to be analyzed. When determining these legal issues, the research always the research the law on the subject matter list, then reach to your conclusion. The legal issue must always reflect the applicable law on the subject. For example, if your facts concern a lawsuit, Andrew is filing against Bet for the possession of real estate. Potential legal issues will include whether and to what extent title to the property was transferred from one individual to the other, whether the deed was properly filed, whether the required purchase price was paid, and whether the another person has a superior claim to the property. So your questions presented section should state the legal issues by identifying the applicable law and major issues in the question form. So the question section should be in a question format. Now brief answer section. So after identifying the legal issues, brief answers comes into the picture, which states the conclusion to the issues that are outlined in the prior section. So what does the law say about these issues? How should they be resolved? So accordingly the answers should be framed with the declarative sentences. Using a prior example, a brief section could read, under the facts of this case, Andrew's suit should not succeed because the transfer of the real property was memorized in writing, supported by the exchange of consideration and filed with the appropriate office. Now, the statement of facts. So, after providing the brief answer, the next section outlines the facts that are relevant to the case. So, the statement of facts tells the reader why the present action is before the court. If you're writing a persuasive memo, tell the story from your client's perspective. If you are presenting this to an attorney who wants an objective opinion on a case, keep the facts straightforward. Beginning legal writers often hereby include only the facts that support their conclusion. This is a mistake. Your fact statement should include all relevant facts, including those that weigh against your client or favored position. This is especially true if you are writing an objective memorandum. So, however, you can safely omit any fact that is irrelevant to the decision or legal issues at stake. Body or discussion section. So this section is of your memo is the meat of the memorandum. It's the purpose is to explain that the law and apply the law to the facts of your case. So this part should be should be organized for the memo by a legal issue or topic under consideration. So use a subheading if your question presented section stated more than one issue. Always start each legal issue by stating the rule of law that you will be applying, followed by applying the legal rule to the facts of your case. The conclusion section. So, this section of the memo should be relatively short and simply state the predicted outcome of the case. It's so after the research of the issues and the analysis of the facts are done, you should be able to determine with the confidence that which party will win and why in the conclusion. Avoid introducing new arguments in the conclusion. Rather, simply restate the likely outcome, being sure to include the appropriate relief that the court will likely grant to the winning party. For example, in our ongoing hypothetical, your conclusion should be Bet will win this litigation and be granted exclusive title to the property in question. Thank you.